Okay, good morning, good afternoon, and good evening. My name is Kernaghan Webb. I am the director of the Ryerson University Institute for the Study of Corporate Social Responsibility, and I am a professor in the Law and Business Department of the Business School here at Ryerson and cross-appointed to the law faculty. And it is my pleasure to be the moderator today for a session with Dr. Nojeem Akinjide Amodu. We will be specifically zeroing in on the issue of shareholders versus stakeholders and approaching this issue specifically from a corporate law comparative governance perspective. Just a little bit of preliminary information before we begin the actual chat. All of these Ryerson University Institute for the Study of Corporate Social Responsibility sessions are designed in pursuit of better understanding of how we can address optimally and minimize the negative environmental, social, and economic impacts of business and maximize the positive benefits of these. So they're all done with a view to constructive engagement on these issues. And all of the sessions are co-sponsored by a number of really terrific Ryerson University student associations, and you see them mentioned on this page. If we could move to the next slide, please. I also wanted to acknowledge that Ryerson University is in the dish with one spoon territory, a treaty, and you can see the details of that treaty here. And if we can move to the next slide. At the Ryerson University Institute for the Study of Corporate Social Responsibility, we always start with this understanding of exactly what is meant by the term social responsibility. As you can see, responsibility of an organization for the impacts of its decisions and activities on society and the environment through transparent and ethical behavior, contributing to sustainable development, health, and the welfare of society, taking into account the expectations of stakeholders, so that's a topic that we'll be coming back to momentarily, is in compliance with applicable law and consistent with international norms and behavior. So this definition of social responsibility assumes that there is compliance with the law as part of its understanding of what a social responsibility company would be doing. And it's not only integrated throughout the organization, it's also practiced through its relationships. So this is, for example, with communities, with customers, with governments, and so on. So this is the definition that we use for all Ryerson CSR Institute events, research, and so on. Next slide, please. The other frame that we approach all issues in terms of how can we optimize the positive impacts of business is this concept of sustainable governance. And as noted here, it starts from the proposition that we've got this very complex, fast evolving, multi-jurisdictional environment with many, many environmental, social, and economic challenges around the world. The idea behind sustainable governance is that the only way we can effectively face these sorts of challenges is by harnessing the unique energies and capabilities of all three, of government, the private sector, and civil society, using a combination of not only government-based, state-based rule instruments, but also non-state rule instruments, processes, institutions, and actors. And sometimes it's all about collaboration, and sometimes there's more of a rivalrous check and balance dynamic at work. Again, this particular lens animates the work that we do at the Ryerson CSR Institute. Next slide, please. Just also wanted to let everybody know that we have a number of talks coming up that may be of interest to everybody here participating today. That all talks are available at no cost, and all of them are accessible after the fact by just going up to the Ryerson CSR Institute webpage and clicking on the events part, and you'll be able to access them. Ryerson University has been well received by a number of different third-party reviewers of our programs here at Ryerson University. That's the third point mentioned. We have a certificate online course available, and that's coming up, and information on how you can patch in for that. And if you would like to be receiving emails regarding upcoming Ryerson CSR Institute talks, just email me and I will put you on that. Next slide, please. So this is an example of the upcoming events in March. We have the one here obviously today with Dr. Amodu, and then another 2 events coming up later on in March. And they both should be very terrific. And as you can see, from quite different perspectives, one with a government official, Canadian Ombudsman for Responsible Enterprise, and then with the individual responsible for anti-bribery, anti-corruption approaches, and generally ESG in a major Canadian-based multinational. Next slide, please. So with respect to Dr. Amodu, we're very, very pleased to have him here speaking with us today. And I was excited when we first started to talk, Dr. Amodu and I started to talk, because he represents the type of individual who I think has a lot to offer in terms of insights, because he's both he's got one foot, so to speak, in the practical world as legal counsel of a extractive sector multinational located in Nigeria, Total, the subsidiary located in Nigeria. And at the same time, he is a research associate at 2 different very good different university-based institutes and or centers, as the case might be. And on top of that, he is the author or co-author of a number of different articles or books. And they, as you can see here, and I've just given a small sampling of them, they're very much focusing in on the sort of issues that we'll be talking about here today. So I'm really looking forward to hearing from Dr. Amodu on those. Just a final point, if during the course of our chat, a thought occurs to you in terms of a question, please feel free to email me, and I will do my best to fold in your question into the conversation that Dr. Amodu and I are having. So thanks, Luke, for going through those preliminary slides. And without further ado, welcome again, Dr. Amodu. And maybe we can just start, if you could, with, can you just give us a little bit of background about yourself? I'm assuming when you were 5 or 6 years old, you didn't say to your parents, Mom, Dad, when I grow up, I want to work for Total as a legal solicitor, and I want to do a lot of research in the area of the distinctions and significance of the distinctions between stakeholders and shareholders. I'm anticipating that was not top of mind when you were 5 or 6 years old. So what was top of mind? How did you, what's your path that led you here today to this particular session?
Wow, that would be a tall order to achieve within well, my journey right from the beginning. I'd always said to myself that I would be a lawyer. And not just a lawyer, but I would like to be a corporate lawyer. Indeed, I started my career with a law firm where, as you know, most, which is always very useful, even when you go in-house into as an in-house counsel. But overall, I've always loved, to be in a position to add value to, make some contribution to one way or the other in everything that I do. And that is something that has, been a motivating factor or in everything I do, right from my school days up till the present moment. And if I can tell, I'm still on the journey.
Agreed. I think we are all still on that journey. The learning continues with every passing day. Just before we get into the details, did you have a role model when you were young because a lot of kids want to be firemen or policemen or a doctor or something like that because there's someone immediately around them that kind of assists them in seeing that this is a possibility. Did you have anyone around you that you could say, that's the sort of thing I'd like to do?
Definitely. That's actually my cousin, Professor Larry Fagbon. I adored him right from my childhood. Though, you know what they say, what do you call a bunch of lawyers, at the bottom of the ocean now?
Oh, yeah.
Maybe I'm having some second thought. Maybe I shouldn't have known him or something. But I really wanted to be like him, dress like him, speak like him. Very great guy.
Very good. So you didn't mind being one of those lawyers at the bottom of the sea. I should just to clarify that there is a joke among lawyers about what do you call a bunch of lawyers at the bottom of the sea? A good start. That's the joke.
Exactly.
Well, very good. So if we could now turn our attention to the issue in front of us, and that is the question of shareholders and what are the responsibilities of corporations with respect to shareholders, and on the other hand, what are the obligations of corporations with respect to stakeholders, a broader term which includes shareholders, but is a broader category, including many other individuals or groups who have interests and could impact on corporations. First of all, why would that matter one way or the other, that there is this distinction between shareholders and stakeholders? Maybe you can just unpack a little bit about why is that a significant issue one way or the other? And in particular, because this is a corporate social responsibility institute, framing it in terms of why that would matter from a corporate social responsibility standpoint.
Yeah, thank you. It's actually, as a matter of fact, some people argue that corporate social responsibility is a direct response to this question of, the debate, shareholders versus stakeholders, that corporate social responsibility is a direct response to it. And it's a very important debate or discussion. Whether this debate is still very live as we speak is a different question. I'm sure we'll get to it eventually. But significantly, talking about shareholders versus stakeholder debate, it's a question of corporate objective. It's the question you ask when you talk about why should businesses or why should companies exist, for whom should managers, in whose interest should they manage the corporation? So basically, the shareholders, if I could just go into some clarifications here. So in terms of the shareholder primacy, which is an assumption essentially, it's a theory based on the assumption that businesses, corporations should be managed for the exclusive benefits of shareholders. And this essentially is the reason behind the expression primacy, shareholder primacy. Although there might be other corporate constituents or constituencies who would also be interested, or who might be influenced, or who could have some impact or could be impacted by businesses such as employees, creditors, suppliers, or the environment or the government. All these, which we popularly call them stakeholders now, according to this shareholder primacy model, they don't really count. The only reason why businesses or corporate executives should manage businesses should be for no other reason other than to maximize wealth of the shareholders. And let me quickly say something in terms of taking us slightly memory lane as well. All this also started as a result of the concept of separation of ownership from control. So when businesses started, and then the owners and the managers, these are were combined in the same entity. Those who own the company also managed, so there was no problem. It was very easy for me as an investor. I've invested money into the company to manage it, to ensure that it's in my interest. But when, as corporations and businesses became bigger and larger, and then there was this question of dispersed ownership, now we talk about the concept of separation of ownership from control. Now there's a set of people who are called the owners of the company, and then some who are not the owners but are actually controlling the company by the directors. So the question became, these directors, we need to ensure that that there was a question of the agency problem. Yes, it's actually called the agency problem. So we need to ensure that these new agents of these owners, how do we ensure, as Adam Smith mentioned, that the easiest, the easiest way to the most interesting way to manage the fastest way to spend money, or the easiest money to spend, is actually other people's money. You enjoy spending other people's money than yours. So how do we ensure that these managers, these directors, these corporate executives, remain focused to ensure that their interests are aligned with the interest of the owners, the shareholders? So this is actually the origin of the shareholder primacy model. It's an assumption which was introduced to ensure that corporate executives manage the businesses for just the interests, the exclusive benefit of the shareholders. So it's a sort of a solution to the to the agency problem, to ensure that there are no detractions, no distractions. Nobody should think about the interest of some employee, or some creditor, or some suppliers. All those would be addressed by contract, or to the extent accommodated by regulation. Essentially, right. Corporate managers manage for shareholders.
Yeah, we don't want to have managers, for example, donating to some big philanthropic cause that has no relation to the business, because that's not what the owners of the corporation, the shareholders, the stockholders would want. And so, yes, the start of this whole issue was, how do we make sure that the agents of the owners are not misusing the resources of the corporation, that they are aligned with what the owners want?
Exactly, but it's just ironical, however, eventually, because we introduced this model, this theory, this assumption into corporate law to solving a particular problem, and then we created in the process another monster. To this end, corporate managers focused fully on maximizing wealth for the shareholders, and it's became very obvious due to a number of factors that it is simply not possible. It's morally, untenable. It's indefensible for corporations to, a corporation cannot exist, cannot survive without certain stakeholders. It is definitely not only the investment from the investors, the shareholders, that actually make businesses to function or to survive in the long term. So this now, is the origin of the stakeholders, oriented theories, which again is a solution to a problem. The stakeholders oriented theories, a solution to the problem created by the shareholder primacy model. Right. And the solution we're trying to create now is, how do we get the business executives to, yes, you may want to acknowledge the fact that there are stakeholders, and shareholders are also part of the stakeholders, but we don't need you to focus too much on the shareholders. We need you to also consider other corporate constituents. You need to think about the employees. They have also invested into these businesses. Their investment may not be in terms of capital, but they also have some investment. There's an investment from customers, from suppliers, and things like that. So the stakeholder theory is all about ensuring that the single-minded approach of the shareholder primacy model is whittled down to ensuring that this model is based on that fundamental assumption that executives should manage corporations or businesses for now the interest of a larger a group called the stakeholders. In other words, corporations do not exist in isolation. They exist based on the recognition and interaction with certain stakeholder groups. Without this constituents, such corporations may not exist. But again, in creating this solution, the stakeholder oriented model, it appears we also created another monster.
A new monster.
Sorry?
A new monster.
A new one. On
Right.
which basis, yes, people like Milton Friedman, simply said things like CSR is, total hogwash. We're simply distracting corporate executives when you tell them to serve several masters. We should keep them focused to just serving one master, the shareholders. So the stakeholder oriented theories, according to the protagonist of shareholder primacy, is actually not in anyone's interest.
Right. But we also now have, in a number of different jurisdictions around the world, at the legal level, and I'll just use Canada as an example, we have the Supreme Court of Canada saying, actually, board of directors, just for you to know that your job is to look after the long-term best interests of the corporation, not the shareholders, the long-term best interests of the corporation. And in the course of looking after the long-term best interests of the corporation, certainly you should take into account the interests and views of the shareholders, but you should also feel free to take into account the interests of any number of other stakeholders, communities, customers, workers, the environment, and so on. And we are saying to you, said the Supreme Court of Canada in the BCE case, that you are not in any way in some form of a straitjacket where the only interest that you can pay attention to is the shareholders. And on top of that, the Supreme Court of Canada said, your job is to look after the best interests of the corporation, acting as a responsible corporate citizen and a good corporate citizen. They specifically used those words. So I guess point number one is this is clearly an example of a legal regime in Canada, which is tipping in favor of the stakeholder model as opposed to the shareholder model. But I think what you're going to tell me is where does the Canadian model fit with, let's say, the American model, the United Kingdom model, the Nigerian model, and the South African model? So please take it away.
Thank you very much. It's really getting interesting now. So essentially, like we said, this is focused on comparative company law. So I'll just take us through what the picture, what it is looking like in some of these jurisdictions you've mentioned. But before that, let me mention that yes, we mentioned shareholder primacy model on the one hand and the stakeholders on the other hand. So, and I said one appeared to be a solution to the other, and then we're trying to create, there might be new problems with the so-called solutions. One thing is settled. So I'm going to begin on this premise that while the case has been made by some that the shareholder primacy model is dominant and there appears to be convergence around the world around shareholder primacy, I think I'm of the opinion that this is not accurate. As a matter of fact, the convergence around the world now is actually towards the stakeholder-oriented theories. And we'll see this from what we have from the next statements I'm going to make in terms of what is obtainable in looking at different jurisdictions. So starting with the UK, for instance, it was a big deal before the 2006 UK's Companies Act. It was a big deal in terms of what exactly would be done in relation to the corporate law system, which was essentially largely dominated by the shareholder primacy model. So before eventually settling for Section 172 of the UK Companies Act, the popular enlightened shareholder value model, which is to the effect that yes, of course, when we're talking about this debate is really for corporate law students. This debate concerning shareholders and stakeholders, for you to know exactly where to find the appropriate sections in the legislation, where to find where a particular jurisdiction might fall. You look at the duty that has been assigned or imposed to the corporate executives, the duties assigned to directors. Now, in terms of that, the fiduciary duties and obligations. So in the UK, for instance, like I said before, it used to be all shareholder primacy, and then there was this long battle and debate. Eventually, that jurisdiction settled for the popular now enlightened shareholder model, which is essentially saying that while it will be difficult, while it is clear that shareholder primacy model is indefensible, it is probably not possible to write in any legislation that corporate executives will only manage corporations for the exclusive benefit of shareholders, of their members. And it is probably also untenable to have it in any legislation, any section, to say that directors, you will only manage businesses to maximize wealth for your members. That has become very clear. It also appears problematic to go the other extreme, to say that corporate executives, you should take the interest of all stakeholders to be equal in ranking. That was the other extreme. So what was done in the UK was to maintain some sort of middle ground, of course, with a lot of criticisms eventually. but they had to settle for it. Someone like the late John Parkinson, wanted something more, like Professor Paul Davies, narrated, that he actually wanted something more, but with the debate going on, they had to settle for the enlightened shareholder value. And what does that say? It simply says that, yes, it is recognized that in considering what will be considered to be the best interest of the company will be, taking, into account the interest of the shareholders, the members as a whole, and then having regard to a few other interests as listed under Section 172. And those interests are other corporate, constituents like, employees, the community, the environment, and things like that. So it's a kind of a compromise, so to speak. Of course, there are lots of criticisms going, after this provision in terms of the real value when it comes to discussions around, corporate accountability, corporate social responsibility, for corporations to demonstrate accountability for the impact of their operations in the society. When there is indeed impact and there are victims, what sort of protection, what sort of remedy can victims take away from such a provision to say corporate executive directors manage this in the interest of the shareholders as a group, however, have regard to? Does that make any sense? So there's been arguments, that has been the major criticism against the ESV, Enlightened Shareholder Value, in the UK. Now in Canada, you know very well the origin of of the Supreme Court when it started in the People's Department stores and wives. That was the origin of where we saw that judicial activism, stating and confirming that yes, there is need to shift. There is need to have that shift from pure shareholder primacy to some stakeholder-oriented, thinking, where the Canadian Supreme Court also, in its judgment, held that corporate executives need not follow the single-minded, narrow-minded approach of simply focusing on the interest of just the shareholders exclusively. Of course, this was confirmed in the BCE and the debenture holders. So, of course, eventually, like someone said, and this is also the situation in the UK, a codification of what was obtainable by, at case law, eventually within the legislation. But the Canadian experience is slightly different because, there was that judicial activism first, which then became later codified. So it was, the judiciary actually, leading the way in terms of what was eventually done with.
Would you say, sorry, but would you say, Dr. Amodu, would you say that the Canadian model and the UK model are the same? You would classify both of them as this enlightened shareholder value model, or would you say that the Canadian model goes a step further than does the UK model? I'm interested to hear your characterization of the two of them.
To be honest,
yeah.
You might not like this answer, but to be honest, my view is just as you would find in other jurisdictions, with little adjustments here and there. I think that the model in the UK and in Canada, they cannot be one and the same, definitely, but they're very similar, but in effect, eventually, I think they're the same. Because In terms of wordings, definitely they are not word for word the same. While the UK experienced this, UK section 172 is talking about have regard to. The Canadian section 122 of the CBCA is talking about may, consider, and they are not limited in that consideration to, those corporate constituents listed. The problem, and I'll tell you the reason why I came to this conclusion, why I said this. But before I go there, let me tell you, the experience in other jurisdictions,
Please.
Especially in Africa. In Nigeria, for instance, we have something similar under the Companies and Allied Matters Act 2020. Now, this repealed the popular Companies and Allied Matters Act 1990 as amended. So it's fresh and new, as recent as 2020. Section 305 of this Companies and Allied Matters Act has something, very similar to what you have to the enlightened shareholder value in the UK, because now it also has something. It went as compared to the 1990 version, which looked clearly to some crude adoption of the shareholder primacy model by simply saying the interest in determining what is considered the best interest of the company is essentially the interest of the shareholders. This section 305 of the new CAMA went a step ahead to say that now, while directors would be, acting in the best interest of the country, of the corporation, of the company, and of course that's been interpreted as the interest of the shareholders as a whole, that they would also, in the process, have regard to, considering the interest of, the environment in the community where companies operate. So that shows some slight improvement to show that even corporate law in Nigeria recognizes that that single narrow-minded approach, will no longer work. And, before I'll still get to your answer, but there's a reason for the focus in Nigeria to actually, for the Companies and Allied Matters Act to actually focus on environment. And I'll go back to this later, because there are other legislations, the Petroleum Industries Act, which also appears to complement this, and that's because of the peculiar situation in Nigeria. The environmental degradation,
right,
in the oil and gas industry and everything. So in Nigeria, there is such improvement. In Ghana, in their Companies Act as well, you will find that you won't find a crude adoption of the shareholder primacy. You'll also find a section in their Companies Act, tilting towards stakeholders, theory. So if you look at the section in the Ghanaian Companies Act, you will look at their section 190, you'll find a similar adoption of an enlightened shareholder value model, saying, yes, consider the interests of shareholders as a whole, but have regard to. The same thing you will find in Kenya. If you check section 143 of the Kenyan Companies Act of 2015, you have something similar to an enlightened shareholder value. In South Africa, it's quite interesting, as what it has adopted is slightly different from the enlightened shareholder value, because it actually goes a step further to create a committee at the level of the board, the social and ethics committee, the SEC. So, but whether it goes a step further or not, it confirms one thing, that shareholder primacy, there is a clear shift from shareholder primacy model to stakeholder-oriented model in companies' legislation. Now, to your question of essentially whether what you have in the UK and in Canada, whether essentially they are the same. To me, the reason why I said they may essentially, amount to the same thing is because while there are differences in all these jurisdictions that I just mentioned, including, the Canadian jurisdiction and the UK in terms of the exact wordings used in the corporate legislation. But in effect, what value will a victim of irresponsibility from a corporation derive from these provisions? The answer to that question, you would find it right there in those provisions themselves. It simply tells you that the stakeholder-oriented models, and this is one of the problems they have, they try to say, corporate executives, please do not focus on shareholders alone, try to consider others. What exactly does that mean? John Parkinson said, the stakeholder-oriented model, has created an unworkable model. It has created an impossibility for directors. Directors are somewhat confused. What exactly are you talking about? And this is the same criticisms, people have against, the judgment of the Canadian Supreme Court in the BCE case. When you say, yes, they should behave responsibly, you should have regard to other interests. What formula are you putting on the table for the executives to adopt to, yes, they would recognize some of these interests? How do they balance competing stakeholder interests? How?
I agree with everything that you're saying so far. There's just some key points I want to emphasize. First is that the BCE case basically doesn't say anything about primacy of shareholders. In fact, it says the reverse of that. It says, shareholders, you are one of the stakeholders. The board of directors has every right to consider your interest along with the others. So it doesn't say shareholders and then you can consider others. It says you can consider any of these depending upon the circumstance. So in my opinion, the BCE case doesn't start off from a position of saying shareholders have some higher ranking and then you can consider others. It says you can consider any one of these while fulfilling your duties as looking after the best interests of the corporation, acting as a responsible citizen. So that's point number one. Second point is that let's talk practically for a second here. Let's say, for example, a Canadian corporation registered on the CBCA, you are part of the board of directors, and you receive information, perhaps in a brown envelope, anonymously, and perhaps an NGO literally comes and knocks on your door, a non-governmental organization comes and knocks on your door, but they say, look, there is a problem with one of your operations located in a particular province, let's say, or for that matter, in another country. You're a Canadian multinational that operates in other parts of the world. There is a problem. There is a problem, let's say a human rights problem with the community. And you, in your wisdom, as a board of directors, you say, oh, okay, thank you very much for that. And you just put it in the shredder and you carry on. Now, subsequently, there's some major human rights abuse that takes place at that particular subsidiary. In the Canadian model, I would suggest to you that it would be open to litigants to go to the court and say, look, the Supreme Court of Canada has said that the proper thing that you are to be doing as a director is you should be taking into consideration the range of stakeholders that are relevant to looking after the long-term best interests of the corporation. And you received notice that there was a problem and you did nothing. You did not exercise due diligence when you were notified that there was a problem with this particular stakeholder. And therefore, we're now going to hold you liable in tort or whatever it might be. I'm making the case to you now for how, under the Canadian model and the business judgment rule, which we haven't even mentioned here, that a failure to do an investigation and to respond, which is due diligence, human rights due diligence, in that situation would be an abdication of the director's responsibility to, in the right set of circumstances, where a particular interest comes up, in this case, community human rights, and you didn't do it, you will have abdicated your responsibility in that regard. But I'm interested to hear your thoughts on that.
Of course, the itself of the discussion. You know, this issue, the conclusion from what I have read, you know, practically easy for corporate executives to simply go back to the wordings, the exact wordings of the law, to say that what the law requires is we should consider, we should have regard to something, consider. Now, what the law has done is to provide the director, the corporate executives, the opportunity, and the only legal obligation, you know, from the scenario you painted, is for directors to simply say, yes, we received that petition, we received that letter, we looked at it, we read it, we considered it while we were making certain, you know, decisions. And our decision, you know, was simply not different. We considered, yet our decision was still simply the same. I view those corporate executives will still have complied with the provisions of the law as currently worded, whether in Canada, in UK, in Nigeria, in Ghana, in Kenya, or anywhere else. The only obligation they owe in the circumstance, I would not even push it as much as to investigate, to carry out due diligence. Of course, in some few exceptions, especially, you know, considering other legislations outside corporate law, you know, ensure that what, you know, corporations actually carry out certain things in terms of, you know, the modern slavery, the due diligence, you know, obligations under the French vigilance law and things like that. Yes, beyond that, but strictly speaking, corporate law, and these provisions that we're referring to in terms of what they should do as per the requirement of corporate law, I think, in my opinion, that the corporate executives would have complied with the provisions of this law, again, barring all the requirements of other aspects of law, business and human rights, environmental law, whatever it is. They would have complied with the provisions of the corporate law if they can demonstrate that this was simply considered in their board deliberations. And what does it take? To simply write something in the board minutes that this, we received a letter, we received a petition, the managing director, you know, acknowledged this, and some steps were taken, and then eventually nothing happens.
Well, I guess what we would say, though, Dr. Amodu, is that we have the Supreme Court of Canada now saying that there is this ability to consider a range of different interests under the Canadian law, and there's no primacy given to the shareholder interest there. And I think it's going to be up to subsequent court decisions where there actually is an issue, like the hypothetical that I proposed to you, to see what, for example, the Supreme Court of Canada would say constitutes taking into consideration and what constitutes complying with the business judgment rule. We'll just have to wait and see. And of course, as you are saying, they would probably not be reaching any sort of conclusion on that simply by looking at, in Canada, Section 122 of the Business Corporations Act, Canada Business Corporations Act. They would be looking at any other relevant legislation that also puts requirements, obligations on companies to do things, and they wouldn't be making a decision exclusively and only on based upon Section 122, and that's because that is how we do things. That is how decisions are made. They're made based upon a synthesis of obligations, pressures, etc., that are provided by law and provided by other things, such as standards, such as ISO 26000 and other things, that they are in a position to say, this constitutes reasonable care. This constitutes the standard of due diligence that is expected of a particular director in this sort of circumstance. We don't know, and nor I would think, would we expect to know this soon after a decision such as BCE, that there would be a fleshing out and elaboration of this particular point. They've already made a major change, and that is to say, directors should look at the long-term best interest of the corporation. Shareholders are not dominant. They can look at any number of different interests. That in itself is a kind of a new beachhead. That's a new level of understanding about what their obligations are. And we'll look for another case later on that talks about, now, how do you deliver on this? So we are in that situation now, as they say in French, on verra, we will see. We will see. But I want you to turn back to Nigeria and to turn back to South Africa and talk, because I know that was not the full point. That was just kind of a sideline to your conversation. If you could also say just a minute about the United States, because it is kind of the elephant, as it always is, the elephant in the room. So maybe say a bit about the elephant, because if you don't, it might trample all of us.
So, well, essentially, as you know, from what I have seen, almost everything, started, from the United States, the business judgment rule, the concept of CSR, what we call companies or corporate law today, everything is believed to have started from the US. So it is not very strange also to say that what we're talking about in terms of stakeholder oriented model, as you now have it in other jurisdictions. You have that also in the US. But what is interesting is that while you can talk about other jurisdictions such as Nigeria, Ghana, UK, you probably will be with some federal legislation with specific provisions on the stakeholder-oriented model, or you would have to look into specific state laws in the US. But those you would consider are also tilting towards the stakeholder-oriented model. As a matter of fact, I think I saw that in the writing of Melvin, the other time, that stakeholders. It was because of the impact of the shareholder primacy model, when the society, the government actually saw the impact in terms of the Enron collapse and things like that. That was also what led to legislation such as the Sarbanes-Oxley and things. So in the US, and probably this would lead to some conclusions I will reach eventually, there's been more of that bold effort to address specifically certain concerns, which have been noticed So for instance, when it was saying that the shareholder primacy model was driving, business executives mad in terms of they wanting to maximize wealth at all costs, for their shareholders, and them doing all sorts of things. Legislation was passed specifically to ensure, to address, to the gap. Of course, there was a lot of noise when the Sarbanes-Oxley Act, came out in terms of its extraterritorial jurisdictions and things like that. But that kind of reaction, legislative reaction, with clarity that this is how it should be, and that is exactly what appears to be missing now. Across all, many jurisdictions, in terms of what exactly do we want to do. Yes, we know there is that, should we say there is still that debate in terms of shareholder versus stakeholder? In my view, I think that debate may not be really, be real anymore. Like I said, when, authors like Hansmann and Kraakman, when they said in 2001 that it was end of history, and they were claiming dominance of the shareholder primacy and the convergence towards shareholder primacy, they maintained this same assertion in 11 years later in 2012. But I think, like I said earlier on, I think it is settled now. There's a clear shift. No one can confidently talk about a dominance of shareholder primacy anymore. The best case scenario, we could use expressions such as prevalence, that it is still there across different jurisdictions, but it is definitely not dominant. And the convergence is, tilting towards the stakeholders. So in Nigeria, like I mentioned earlier on, so by virtue of that section 305, subsection 3, for instance, she would have a specific provision saying corporate executives now, directors, you should, in managing, in promoting the success of the company, to determine what the best interest of the company is, consider the interest of the shareholders, the employees, and then, the interest of the environment in the community where you operate. Now, this is very interesting. Like I said earlier on, it complements. As a matter of fact, it sounds as it's a foundation for one other legislation, in the oil and gas industry, the Popular Petroleum Industries Act, where, and this is particularly important to our discussions on, in relation to corporate social responsibility. In this part of the world, in Nigeria, CSR otherwise, was always, conceptualized as some, charity, corporate charity, giving back to the society from the excess, from the surplusage of corporations. So now there's a clear demonstration now. And in my view, such conception of CSR, you could also trace it to shareholder primacy model, because it's about making all the profits in the whole world. However you're going to make it, doesn't matter. Then take a little out of that profit and give back to the society to promote, to build some, some schools, to sponsor, give some scholarship. That to me, is just a confirmation or a projection of the shareholder primacy model. But like I said, thankfully, we have moved away from there. Now, by virtue of that Petroleum Industries Act, companies operating in the oil and gas industry now, they now have a duty, a legal duty by that law to establish what is called a host community development fund. Now, and this is not in any way a question of these companies simply setting out some part of their budget of their money and then pumping into the host communities. No, it has gone beyond that. Now it's a question of setting up a proper entity, another company where representatives from these communities are the ones, controlling almost this. Although that would not be too accurate to say that they are controlling, because the set law, the company still has a lot of say in terms of what happens and what projects would be executed within these communities, what kind of environmental activities or cleanups will be done. The company still has a lot of say. But unlike what was there in the past, where companies were simply dictating the pace, the business community dictating the pace as far how to demonstrate responsibility and accountability within the communities. Now that is no longer the case. It's a case of doing proper mapping, need assessment. You need to understand. You need to hear from the communities. They will tell you the exact impact of your operations, even if you fail to see, within these communities. These are all these have now been recognized within the law in Nigeria. So it's a legal duty. This is a demonstration of the clear shift away from corporations simply saying the business of business is business. The only reason why we exist is to make profit, or the only reason why as directors, the only focus we should have is to maximize profit for our shareholders. That is definitely no longer the case in a jurisdiction such as Nigeria, where now, if you are a company, like I said, apart from the provision in the 2020 CAMA, which says that as corporate executives, you must have regard to the environment in that community. You also have that backed by the PIA, the Petroleum Industries Act. So that is clear. If you move away from Nigeria, you have something very interesting in South Africa as well. In South Africa, under by virtue of section 72, subsection 4 of the South African Companies Act 2008, it came into effect 2011. Now, you also talk about something very, very interesting, the social and ethics committee, similar to what you have in India, but this is actually quite unique. I'm more interested in this because the one in India was still talking about,
philanthropy.
Sorry?
Philanthropy. It's basically sounds like philanthropy. Yeah.
Exactly, sounding like philanthropy. So, but the one in South Africa, although it's not perfect, it's definitely not perfect, but some ingenuity going into it, such that of course I will tell you the criticisms and the major one against it, but it shows some demonstration in terms of shift from shareholder primacy model. Now corporations are now required to set up that SEC at the level of as a board committee, right, who would ensure proper consideration of stakeholder interest. You recognize them, you consider them, and you balance them in exercising business judgments, and you will be questioned if you don't do so. But the major criticism, who will question you if you do not consider these other stakeholder interests? Apart from creditors as stakeholders who appear to enjoy some kind of protection at corporate law, the question is other corporate constituents. What level of comfort do they have with all these? Yeah, please go ahead.
I'm very much liking what you're saying, and my interpretation of it is that what we're seeing is a move away from the explicit shareholder primacy model to a model which acknowledges that there are multiple stakeholders to consider, and there's variations from one jurisdiction to the other as to exactly how that's framed and probably exactly the implications. But you could say that we're kind of we're moving from a toehold to a foothold in terms of the stakeholder model. And then from that stakeholder model, that basic stakeholder model that we're starting to see coming out, there are things that are being built on top of that, such as in Nigeria, the particular petroleum things you're talking about, such as in South Africa. I would argue that in Canada, we have a particular long-standing historical injustice, which is in relation to our First Nations peoples. And we are in the process now of building in this free, prior, and informed consent notion that has been imported from international law, the principles for business and human rights, for example. We're in the process of kind of channeling that in and ultimately codifying that into Canadian law. And I would argue that ultimately the way that's going to play out will be with respect to the board of directors and what it is they have to do as part of their fiduciary obligations to consider relevant interests. And this is where I think things get really interesting. Up until now, I would say that you and I have been treating shareholders as being a homogenous group of individuals who are hell-bent on short-term profit maximization. But the reality is that the shareholders come in all shapes, sizes, colors, etc. And so in terms of remedies, because that's what you're getting to now, who's going to say something? You're basically asking who's going to be able to do something if the directors doesn't do something properly? Who's got that right? It's the shareholders actually do have specific capabilities under corporate legislation, and it doesn't take a major, although oftentimes would be a major institutional investor to take an action on that. All you have to do is have the minimum number of shares, and you can bring a legal action on that basis. So I'm suggesting to you, I agree with you that if you're not a shareholder, that your legal remedies are less immediately evident. But in fact, in the shareholder category, using this new toehold, foothold that we're talking about, it could be the shareholders who are bringing the legal action. Just a suggestion. I also have got a question for you from one of our listeners. So, but please go ahead.
Yeah, so let me just quickly say this about the problem with, yes, it's something, just 2 points from me. I also do not really appreciate or like this, kind of narrative where we paint the shareholder group as some, monster group where, they don't really have the interest of the wider society at heart and they're just there for return on investment. I don't like that for some reasons. But most importantly, I would say that without shareholders in the first place, there wouldn't be these corporations. So let us understand that fact. Certainly. Without them, without their investment, these corporations would not exist. So even if we're not according shareholders some priority as, primacy, as the shareholder primacy did, some kind of respect, should be accorded in terms when we're speaking about, corporate constituents. That's number one. But the problem with the shareholders, as a stakeholder group, is the fact that everything about corporate law, as we know it today, almost everything about it is geared towards protection of investment, protection of the shareholders. And, evidence has shown that the shareholder group, they are actually not the best group to do sometimes what is best for even the company itself, as most of the time they are also after what is beneficial to themselves. And this is the reason why in solving one problem, we should be very careful not to create another problem. So in solving the agency problem, for instance, don't forget, we started introducing the share scheme to ensure that corporate executives are also becoming shareholders. Now, we are assigning obligations to corporate executives as fiduciaries. These same corporate executives have become shareholders. So in whose interest are they going to be operating? In whose interest? So whatever they do, the shareholder group, the shareholder group would always, be at, they'll always enjoy. Why, while, it appears, the reverse is the case when you're talking about other corporate constituents. And this is the reality, and the implication of this, and I hope we will get to it before the end of this session, in terms of other aspects of the law, especially, I like what you said about business and human rights. They are far-reaching. They are far-reaching. The fact that corporate law as we know it today appears to be isolated from, considering the wider societal impact of what is done within the corporations. And the only thing it is focused on, securities law, corporate law, is about protecting investment. Peter Munchlinsky and Paddy Island, they said it. The whole world, everything about everything can be summarized in one word: financialization. Yes. Financialization. Financialization of the world economy. Corporate executives are afraid they're going to lose their job if they don't behave properly and have, proper returns on investment for shareholders. So how can we possibly be talking about protecting or safeguarding the interests of the stakeholders by simply relying on shareholders to do the right thing? I don't think that will work. I don't think so.
I don't either. I think what we have, well, I look at myself. I, as a human being, am an imperfect work in progress. And I would say corporate law is an imperfect work in progress. However, it is in progress. What I'm seeing is movements in the right direction. I'm just going to give you a few examples here. Even if we take the view of shareholders and investors as being very much a short-term profit maximization in terms of their orientation, that can be used for the benefit of society as a whole. I'll give you an example of that. Let's say a company fails to take into consideration something that's going on in one of their communities, that human rights example that I gave to you before. What shareholders can do, because there's an obligation of businesses under securities legislation to disclose what are the risks, and what are the policies that you're using to address those issues, and what is the performance in relation to that. An investor who really only cares about the short-term wealth maximization is going to be able to use those provisions, even though he's, if I can be so blunt, a money-grubbing, short-term oriented person. He will be able to bring litigation, and this has happened, against companies who have, it's turned out, failed to address a particular, let's say, human rights risk. And so therefore that investor can say, my shares went down in value because you didn't properly take into account this interest. Now remember, this particular shareholder really doesn't give a X about that sort of thing, but he will be able to bring that lawsuit nevertheless, even though that's really not his concern, because it's in his financial best interest to bring that. So what I'm talking about is, how that there used to be that expression that the Lord works in mysterious ways. Well, I would say the law works in mysterious ways. You talk about the unintended consequences. There are unintended consequences of a positive nature that result from creating these beachheads. We're making progress. We're creating opportunities where there must be disclosures made, and they must be made on this thing and that thing. And if they fail to do this thing or that thing, it leaves open the possibility for even the money-grubbing, short-term interested shareholders to bring actions, not because they give an X about the environment or human rights, but because, oh, I have lost money. My shares have gone down in value because of this litigation, or because this mining company has had to abandon this entire project in a particular country and the billions of dollars they've invested because of their poor decisions. And this has happened. this has happened. So I'm not dreaming up a scenario that hasn't happened. This has happened, right through to the litigation and the settlements. So I'm kind of, what I'm suggesting to you is that there have been some portals, there have been some doors that have opened up on the corporate governance vehicle that allow for penetration of these ideas, that allow for further elaboration on these ideas. Whether or not they will happen, I don't know. But what I can say is the trajectory, the direction is in this way. And so we will see, as I go back to the French, on verra. But I do want to get back to a question that one of our participants happens to be a gentleman from South Africa. I'm just going to read it out because that way I know I will be saying it exactly the way he said it. He said, I'm interested in sanctions. And I think when he says sanctions, he means penalties. He says it's a popular word at the moment, but in the content of fiduciary responsibility and liability, if a board decides to, in effect, opt for the shareholder primacy model, and that leads the company and its management to prioritize profitability and return to shareholders over any other consideration, what are the legal trends and landmark cases that indicate on what basis the court may step in and sanction, and I think, again, he means penalize the directors, and relatedly, what is the cause of action and the remedy? So I just wanted to convey exactly what he said, and thank you very much. I'm not going to name your name because that's our policies. We don't name names of people who are asking questions, but thank you very much for that question. And back to you, Amodu.
Yes, thank you very much. I think my understanding of that question is, so now corporate executives exercising business judgments, underpinned by shareholder primacy, and then what remedies or sanctions could the victims explore as a result of this. This is exactly what we're talking about, that this is the gap as we speak today.
Right.
Everything we're talking about, everybody, as a matter of fact, some people don't want to hear anything stakeholders theories anymore, because some people believe that it has created more problems than solution. The reason is that everybody is saying, yes, corporate stakeholders, we need to safeguard interests, human rights, employees, contractors, all that. But when things go wrong eventually, now do not forget, in answer to your question, the response I'm providing is not in any way suggesting that there could not be, and there, as a matter of fact, would be solutions, course of action you could explore in other aspects of law. We were talking about corporate law here. At corporate law, it would be extremely difficult. Extremely difficult. So to answer your question, I am not aware of such clear, provisions within our laws of, corporate law. I've seen a couple of provisions in the CBCA in Nigeria, where again shareholders are the ones, whether by derivative actions and are the ones who will be entitled to bring in actions. Now, the law also, and I was going to say this about judicial activism, especially as it appears to be working very well in Canada. There's an extent that there are limitations to judicial activism before it becomes judicial rascalism or judicial rascality. Our courts can only expand the provisions of the law to an extent as it is written. Most corporate legislations now, including in South Africa, to your question, I have not seen a provision which affords corporate stakeholders, apart from the shareholders and probably creditors, such opportunity to bring an action, for instance, to question the business judgment, for instance, of the directors. I have not seen. And this is the reason why I've written about this in some of my contributions in my book, in my articles, that I think the solution, and if you can allow me to say this, I think the solution is we need to think differently. We need to. We've been trying to impose obligations on corporate executives for far too long. Why don't we stop this? Let us impose the obligations on the company itself, not on the corporate executives. Now, the shareholders have the rights, the powers to hire and fire. They would always retain the business executives. They have the opportunity to retain the best, who would ensure that they comply with the provisions of the law. What governments need to do in reaction to the society is evolving. Corporate law too should evolve. Other aspects of the law, they are all evolving. You see in other jurisdictions, in environmental law, in business and human rights, you talk about what is happening at the level of the EU. We are talking about mandatory, corporate sustainability due diligence. And the business community are saying that there's nothing they can do about it. It's going to happen. It's only a matter of time. Because it has become very clear that we cannot go on the basis that it has to be profit and profit and profit. You need to consider the interest of others. If that is settled, then what do we do to help corporate executives to balance this? My solution, my proposal is, let us rely on the business judgment rule. That as long as the decisions originate from disinterested, informed, and good faith decisions of these directors, there's no need to second guess them. Let us leave the business judgment. What we should, however, do is to take some, to borrow something from evidence law, such that when there is a violation of a stakeholder's right, corporate law should devise a mechanism through which the only thing the victim needs to establish is that there is such violation. The onus to establish accountability or otherwise should be on the business. The business should demonstrate that it has acted reasonably, accountably, and responsibly by identifying, considering, and balancing such stakeholders' interests, by complying with the UNGPs. Professor John Ruggie, blessed memory, did a fantastic job with the UNGPs on how to map out, on how to do proper due diligence. I think we can rely on these two in corporate law, such that let us put the obligation on these companies and then afford some remedy, real remedy, effective remedy, give effective access to victims, even in corporate law, not just in other aspects of law. So to answer his question, I am not aware there are such opportunities for sanction at corporate law, apart from
oppression
available to shareholders and creditors.
Right. Couple of points. We know, if I can make a sort of an analogy to a family and parents. So if you're a father and there's law that applies to you in everything that you do. Everything that you do with your family, everything you do with your neighbors, and so on. There's law. There's also religion. And religion is another method that assists us in deciding, as a father, for example, what it is you do. And there's culture, and there's tradition. Why would we need to say that a father needs to rely exclusively on any one of those things? Why would we not say that a father essentially synthesizes the normative messaging that comes from the law, the normative messaging that comes from religion, the normative messaging that comes from culture, the normative messaging that comes from tradition, and synthesizes that, and on that basis makes his decision as a father? So why is it, I'm just interested as to why it is you believe that everything has to be encompassed explicitly within the corporate governance shell, if in fact it's addressed in the aggregated shell that constitutes the environmental laws, the human rights laws, and the corporate governance laws that encompass and surround the father, the parent, in this metaphor, which is the board of directors. Is that not, in realistic terms, is that not how we approach things in law? Is that we surround whatever actor, whatever is our targeted actor, with a range of different points, prods, pushes, persuasions, sanctions, and so on. And it's the combination of those that leads to any particular action. And to believe that any one of those must address all of those things it would be great if it does it, but if we can say that this is the direction that we're moving towards improvements with respect to corporate governance, understood as within a broader context that includes business and human rights, business and the environment, and on and on and on, is that not moving in the right direction?
In my view, thank you very much for that. In my view, I think that yes, corporate law is moving in the right direction. However, it is very important to say this. Very important. Without corporate law, corporations will not exist.
Understood.
It's not possible. So how can the set of rules and regulations with such fundamental role take the back seat when it comes to determining the role of such entities it has created in the society? How? That is indefensible. So how will business and human rights activists, or I don't know what they are called, or human rights, protagonists, say that the only problem we see with the situation now is corporate law? Corporate law appears to be taking us 10 years backwards when we are making inroads, of 20 years ahead. So it is unacceptable. Corporate law may appear to be progressive. It is clear. We are no longer at the realm of shareholder primacy. We have definitely moved away from the argument of dominance as canvassed by Hansmann and Kraakman. We have. The convergence now is towards stakeholders theory. But I am saying, some of us are saying that corporate law still has the potential for so much more. Agreed. And we don't have to stifle investment. We don't have to kill our businesses for corporate law to work, because we shouldn't forget, corporate law is not there to serve just some, to make some people richer or to transfer the role of government to businesses or vice versa. But we're saying that corporate law, some nice rules can be designed at corporate law to ensure that there will be sufficient freedom afforded to corporate executives to still work very hard to make profit, but at the same time, not at the expense of other corporate constituents. And it is possible. Before, let me quickly, close by saying this. Before, the argument used to be that corporate executives should not be made to serve multiple masters, that it is not possible. It is undue detraction. They should serve only one master. That is the argument. But it has become very clear. The business roundtable, everybody came out. The academia came out and said that is hogwash. Every day, corporate executives are serving multiple masters, and it doesn't affect their work. It doesn't affect efficacy, productivity, or efficiency. So it's high time we wake up to new realities. Corporate law has so much to offer. So much to offer. Of course, there will always be dependence on other principles in environmental law, business and human rights, and all that. But we need to address certain fundamental things at corporate law. And in my view, we have not gotten there. clearly, and then but we need to inject certain things to bring clarity to corporate law. We need to expand the meaning of the best interest of the corporation to clearly state, not hiding anything anymore. Let corporate legislations around the world clearly state what is meant by best interest of the corporation. It's as simple as that. There is no need to say may have regard to, may consider. There is no need. We should simply trust and rely on the business judgment of corporate executives. If they don't do well and corporations suffer losses and investors lose, it is because of the corporate executives they have appointed. If you don't like your corporate executives, remove them. You have the power.
Well, first of all, Dr. Amodu, I love your passion, and I think that as we move forward around the world addressing the corporate governance question and where it goes next, it will be people like you who have a grasp of what's going on in multiple jurisdictions and have a view as to where things can go that are going to play a very important role. And I'm delighted that we've had a chance to talk about this. I'll also say, when I look back over things like the Donahue v. Stevenson case, so that was, again, judicial activism to basically articulate the concept of negligence. The concept of negligence, I think you'll agree with me, is now a concept that spread from that court decision to legislation, to fundamental concepts of law that have infected every part of the legal system. And I would argue that a similar pathway is possible with respect to corporate governance, working in conjunction with and as the other parts of the law progress. And at some points, right now, I would agree with you, corporate governance is behind, but there are very promising toeholds, footholds that can become strongholds. And the existence of, for example, standards that articulate, here is what is expected of directors, here's what is expected of them, so that in any particular situation, that constitutes the reasonable care due diligence that then is cemented into place by a court in any particular circumstance. Maybe that's the next step that will happen, or maybe the next step will happen through legislation directly. I don't know. But what I do know is where I think we're in complete agreement is the direction is positive, but perhaps not fast enough for any of us. But it has been really enjoyable and fascinating talking to you, Dr. Amodu. I want to wish you continued success with your work. And I do hope we have another opportunity to talk about this later. And we're in a situation to raise glasses of champagne on the amazing progress that's been made on these topics. But in the meantime, continued best of luck with your work. And thank you again on behalf of Ryerson University, and in particular, the Institute for the Study of Corporate Social Responsibility.
Thank you very much. Thank you for the invitation. It's been a pleasure. Thank you. I hope to see you around.
Very good. All the best.